Assalamualaikum warahmatullahi wabarakatuh. My name is Ariessa binti Mohamad Tahir, metric number 059673. And for e-portfolio presentation part A, I will talk about crime of aggression. Definition of crime aggression. Crime of aggression is defined in Article 8 of Rome Statute, which was adopted from the 2010 Review Conference in Kampala, Uganda. According to Article 8 of the Rome Statute, crime of aggression can be defined as a planning, preparation, initiation, execution by a person in the position effectively to exercise control over or to direct the political or military action of a state and of an act of aggression which, by its character, gravity and scale, constitutes a manifest violation of the Charter of the United Nations. Number 2, act of aggression means the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in by another manner inconsistent with the Charter of the United Nations. In accordance with United Nations General Assembly Resolution 3314 of December 14, 1974, acts of aggression include the invasion or attack by the armed forces of a state of the territory of another state, or any military occupation, however temporary, resulting from such invasion or attack, or any annexation by the use of force of the territory of another state. Number 2, bombardment by the armed forces of a state against the territory of another state, or the use of any weapons by a state against the territory of another state. Number 3, blockade of the post or coast of a state on the land, sea, or air forces, or marine or air of another state. Number 4, use of armed forces of one state which are within the territory of another state with the agreement of the receiving state in contravention of the conditions provided for in the agreement. Next, the action of a state in allowing its territory which it has placed at the disposal of another state to be used by that other state for perpetrating an act of aggression against the third state. And lastly, the sending by or on behalf of a state of armed bands, groups, irregulars, or mercenaries which carry out acts of armed forces against another state of such gravity as to amount to the acts listed above or its substantial involvement therein. There are 3 elements that needed to be proved by the court in order to constitute crime of aggression. Element number 1 is political or military leader. The person must be a person in a position effectively to exercise control over or to direct the political or military action of a state. Number 2, directly involved. The perpetrator was involved in the planning, preparation, initiation, or execution of such a state act of aggression. And number 3, the act must be in accordance with UNGA Resolution 3314. It must, by its charter, gravity, and scale, constitute a manifest violation of UN Charter. This implies that only the most serious forms of use of force between states can be subject to court's jurisdiction. Activation of crime of aggression in ICC. The adoption of the resolution of the crime of aggression came after 10 days of intense diplomatic negotiation that stretched into the early hours of 15 December 2017. The resolution that was finally adopted entered into force on July 2018. It also stipulated that the ICC will not have jurisdiction over ICC member states or their nationals that have not ratified these amendments in the case of a state referral or proprio motu on one's own initiative investigation which was requested by the prosecutor. However, ICC judges maintain their independence in ruling on jurisdictional matters, and referrals from the UN Security Council have no jurisdictional limitations. ICC's limitations in prosecuting crimes of aggression. The ICC struggles with some severe and structural activities. The ICC also has limited resources and faces institutional restrictions, and on the other, it is manipulated by the states. The ICC is also criticized for alleged selectivity in dispensing justice. Thank you.